Good morning, members of the jury. As I've alluded to before, you all have heard all of the evidence that you're going to hear in this case. The next thing that happens is that I'm going to read to you the jury charges. These three charges contain all of the law necessary to enable you to reach a verdict. The definition of a word is defined by our laws here in Texas. You'll find it in the jury charges. If it's not, you just use your ordinary understanding of that word. You will have the jury charges back with you during your deliberations, as well as all of the evidence that was admitted for all purposes in this trial. First thing I'm going to do, the law requires that I read to you these charges, all three of them, out loud. After that, because the state has the burden of proof, you'll have arguments from the state. It's my understanding Mr. Lewis will open up on behalf of the state. Then you'll hear arguments from the defense. It's my understanding that Mr. Brissett will open on behalf of the defense. And since the state, as I said before, has the burden of proof, Mr. Snipes will conclude for the state, and in this case, will be yours. Cause number F1718595. State of Texas versus Roy Oliver in the 292nd Judicial District Court, right here in Dallas County, Texas. Jury instructions, members of the jury. Roy Oliver, the defendant, stands charged by indictment with the offense of murder, alleged to have been committed on or about April 29, 2017 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. The following instructions are the law applicable to this case. You were instructed that you shall read these instructions as a whole. Definition of murder. A person commits murder if he, 1, intentionally or knowingly causes the death of an individual, or 2, intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Definitions of terms. Actor means a person whose criminal responsibility is an issue in a criminal action. Page 2. A deadly weapon is a firearm or anything manifestly designed, made, or adapted for the use of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. A firearm is any device that's designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Individual means a human being who is alive. Serious bodily injury means bodily injury that creates a substantial risk of death, or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Bodily injury means physical pain, illness, or any impairment of physical condition. Definitions of mental states. Person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Page 3. Person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Transferred intent. A person is nevertheless criminally responsible for causing a result if the only difference between what actually occurred and what he desired, contemplated, or risked is that a different person was injured, harmed, or otherwise affected. Murder. Bearing in mind the foregoing instructions, if you unanimously find from the evidence, beyond a reasonable doubt, that on or about April 29, 2017 in Dallas County, Texas, the defendant, Roy Oliver, unlawfully, intentionally, or knowingly did cause the death of Jordan Edwards, an individual, hereinafter called deceased, by shooting deceased with a firearm, a deadly weapon, or, page 4, unlawfully did in there intend to cause serious bodily injury to Jordan Edwards, and did then and there commit an act clearly dangerous to human life, to wit, by shooting the deceased with a firearm, a deadly weapon, and did thereby cause the death of Jordan Edwards, an individual, or intended to knowingly or intentionally cause the death of Vidal Allen by shooting him with a firearm, a deadly weapon, and instead shot and killed Jordan Edwards, an individual, with a firearm, or intended to cause serious bodily injury to Vidal Allen, and did commit an act clearly dangerous to human life by shooting Jordan Edwards with a firearm, a deadly weapon, that caused the death of Jordan Edwards, an individual, then you will find the defendant guilty of murder as charged in the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next go on to consider the lesser included offense of manslaughter. page 5. Our law provides that a person commits the offense of manslaughter if he recklessly causes the death of an individual. Recklessly has been defined previously in this charge, and that definition applies to the offense of manslaughter. If you unanimously find from the evidence, beyond a reasonable doubt, that on or about the 29th day of April, 2017 in Dallas County, Texas, the defendant, Roy Oliver, did recklessly cause the death of Jordan Edwards, an individual, hereinafter called deceased, by shooting the deceased with a firearm or deadly weapon, then you will find the defendant guilty of manslaughter as included in the indictment. Or, while risking recklessly causing the death of Vidal Allen by shooting toward him with a firearm, did recklessly cause the death of Jordan Edwards, an individual, by shooting him with a firearm or deadly weapon, then you will find the defendant guilty of manslaughter as included in the indictment. If you should find from the evidence beyond a reasonable doubt that the defendant is guilty of either murder or manslaughter, but you have a reasonable doubt as to which offense he is guilty of, then you should resolve that doubt in page 6, the defendant's favor, and find the defendant guilty of the lesser included offense of manslaughter. If you have a reasonable doubt as to whether the defendant is guilty of any other offense, is guilty of any offense defined in this charge, you will acquit the defendant and say by your verdict, not guilty. Justification. It is the defense of prosecution that the conduct in question is justified under our law. You are to consider the statutory defense of a third person in determining if the defendant is guilty of the offense alleged. The state must prove beyond a reasonable doubt that the defendant did not act in self-defense of the third person as herein defined. In addition to the definitions already given, the following definitions apply to the issue of justification. Deadly force means force that is intended or known by the actor to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant, page 7. Unlawful means criminal or tortious, or both, and includes what would be criminal or tortious, but for a defense not amounting to justification or privilege. Deadly force in defense of a third person. A person is justified in using force or deadly force against another to protect a third person if, 1, under the circumstances as the person reasonably believes them to be, the person would be justified in using force or deadly force to protect himself against the unlawful force or unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect, and the person reasonably believes that his intervention is immediately necessary to protect the third person. A person is justified in using force against another, when to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if he would be justified in using force against the other, and 2, when to the degree he reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. Page 8, a person who has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force as described by this section. And you may not consider whether such a person failed to retreat and determine whether the actor reasonably believed that the use of deadly force was necessary. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence, beyond a reasonable doubt, that on or about April 29, 2017 in Dallas County, Texas, the defendant, Roy Oliver, caused the death of Jordan Edwards by shooting Jordan Edwards with a firearm, but you further find from the evidence, or have a reasonable doubt thereof, that the defendant reasonably believed the deadly force, when to the degree used, was immediately necessary to protect Tyler Gross against the use or attempted use of unlawful deadly force by Vidal Allen, then you will acquit the defendant and say by your verdict, not guilty. If you do not so find, and you do not have a reasonable doubt thereof, you will reject the justification of deadly force in defense of a third person. Page 9. Availability of justification, innocent third person instruction. Even though an actor is justified in using deadly force against another, if, in doing so, he also recklessly kills an innocent third person, the justification afforded by the law is unavailable in a prosecution for the reckless killing of the innocent third person. Bearing in mind the foregoing instructions, if you find from the evidence that the defendant was justified in using deadly force against Vidal Allen, but you also unanimously find, beyond a reasonable doubt, that in doing so the defendant also recklessly killed Jordan Edwards, and that Jordan Edwards was an innocent third person, then you will find against the defendant on the justification defense. Constitutional rights. All persons are presumed to be innocent and no person may be convicted of an offense unless each element of that offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt in his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless you are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case, page 10. The state has the burden of proving the defendant guilty and must do so by proving each and every element of the offense charged beyond a reasonable doubt. This burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, you must acquit the defendant. The state is not required to prove the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes all reasonable doubt concerning the defendant's guilt. Evidentiary instructions. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you think or surmise the opinion of this court to be. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. Do not be concerned with the reasons for such rulings and draw no inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you, page 11, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that you may consider all relevant facts and circumstances surrounding the killing, if any, and the previous relationship existing between the defendant and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the offense alleged in the indictment. You are instructed that if there is any evidence before you in this case regarding the defendant having committed acts other than the offense alleged against him in the indictment in this case, you cannot consider that evidence for any purpose unless you first find and believe beyond a reasonable doubt that the defendant committed such other acts, if any were committed, and understanding that said evidence cannot be used against the defendant as any evidence of guilt in this case. You may only consider that evidence for the purpose of aiding you, if it does aid you in determining the state of mind of the defendant, or to rebut a defensive theory, and for no other purpose, concluding instructions. The jury is only permitted to receive evidence regarding the case from the witness. During your deliberations, you are not to consider, refer to, or discuss any matters or issues not in evidence before you. You should not consider or mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown to you by the evidence. You are not to talk about this case to anyone who is not a member of your jury. Mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling is to play no part in your deliberations. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to their testimony, which you are bound to receive and to follow the law from this court. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by your presiding juror, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you may have. After argument of counsel, you will retire to the jury room and select one of your members as your presiding juror. It is the presiding juror's duty to preside at your deliberations, page 13, and to vote with you in arriving at a verdict. Your verdict must be unanimous. And after you have arrived at your verdict, you may use one of the attached forms by having your presiding juror sign a particular form that conforms to your verdict. After you have reached a unanimous verdict, or if you desire to communicate with the court, please use the jury call button on the wall, and the bailiff will respond. This is signed by me, Judge Brandon Birmingham, presiding judge of the 292nd right here in Dallas County. Page 14 has your verdict forms. They are mutually exclusive. Top verdict form reads as follows. We, the jury, unanimously find the defendant guilty of murder as charged in the indictment. There's a spot for the presiding juror to sign and print his or her name should that conform to your unanimous verdict. Or, we, the jury, unanimously find the defendant guilty of manslaughter as included in the indictment. Again, there's a spot for the presiding juror to sign and print his or her name should that conform to your verdict. Or, we, the jury, find the defendant not guilty. And again, there's a spot for the presiding juror to sign and print his or her name should that conform to your verdict in that particular call. Cause number F17005 76-B, the State of Texas versus Roy Gilwood Oliver, in the 292nd Judicial District Court of Dallas County. Jury instructions. Members of the jury: Roy Oliver, the defendant, stands charged by indictment with the offense of aggravated assault by a public servant, alleged to have been committed on or about April 29th in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. The following instructions are the law applicable to this case. You were instructed that you shall read these instructions as a whole. Offense definition. A person commits the offense of assault if he intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault by a public servant if he commits assault and he uses or exhibits a deadly weapon during the commission of the assault, and he is a public servant acting under color of his office or employment. Page 2, definition of terms. Bodily injury means in physical pain, illness, or any impairment of physical condition. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Public servant means a person elected, selected, appointed, employed, or otherwise designated as an officer, employee, or agent of the government. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Definition of mental states. A person acts intentionally or with intent with respect to the nature of his conduct and with his conscious objective or desire to engage in conduct. Page 3. A person acts knowingly or with knowledge with respect to the nature of his conduct or the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. Aggravated assault by a public servant. Bearing in mind the foregoing instruction, if you unanimously find from the evidence beyond a reasonable doubt that on or about April 29, 2017 in Dallas County, Texas, the defendant, Roy Oliver, did unlawfully then and there intentionally or knowingly threaten with all alum with imminent bodily injury, and said defendant did use or exhibit a deadly weapon to it, a firearm, during the commission of the assault, and said defendant was then and there a public servant, namely a City of Ball Springs police officer acting under color of his office or employment, and you will find the defendant guilty of aggravated assault by a public servant as charged in this indictment. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. Justification. It is a defense to prosecution that the conduct in question is justified under our law. Page 4. You are to consider the statutory defense of the third person in determining if the defendant is guilty of the offense charged. The state must prove beyond a reasonable doubt that the defendant did not act in defense of the third person as herein defined. In addition to the definitions already given, the following definitions apply to the issue of justification. Deadly force. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Unlawful means criminal or tortious or both. It includes what would be criminal or tortious, but for a defense not amounting to justification or privilege. Deadly force in defense of the third person. A person is justified in using force or deadly force against another to protect a third person if, under the circumstances as the person reasonably believes them to be, the person would be justified in using force or deadly force to protect himself against the unlawful force or unlawful deadly force he reasonably believes them to be threatening the third person he seeks to protect, and 2, the person reasonably believes that his intervention is immediately necessary to protect the third person. A person is justified in using force against another to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another. 1, he would be justified in using force against the other, and 2, when to the degree he reasonably believes that the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. A person who has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who has not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force as described in this section, and you may not consider whether such a person failed to retreat in determining whether the actor reasonably believed that the use of deadly force was necessary, page 6. Now bearing in mind the foregoing instructions, if you unanimously find from the evidence, beyond a reasonable doubt, that on or about April 29, 2017 in Dallas County, Texas, the defendant committed aggravated assault by a public servant as alleged in the indictment, but you further find from the evidence, or have a reasonable doubt thereof, that the defendant reasonably believed that deadly force limited to the degree used was immediately necessary to protect Tyler Gross against the use or attempted use of unlawful deadly force by Vidal Allen, you will acquit the defendant and say by your verdict, not guilty. If you do not so find, and you do not have a reasonable doubt thereof, you will reject the justification of deadly force in defense of a third person and find the defendant guilty of aggravated assault by a public servant as charged in the indictment. Constitutional rights. All persons are presumed to be innocent. No person may be convicted of an offense unless each element of that offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at this trial. The law does not require the defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the page 7 defendant, unless you are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. The state has the burden of proving the defendant guilty and must do so by proving each and every element of the offense charged beyond a reasonable doubt. This burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, you must acquit the defendant. The state is not required to prove the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes all reasonable doubt concerning the defendant's guilt. Evidentiary instruction. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted. Do not be concerned with the reasons for such rulings and draw no inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine, page 8, what weight should be given to such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that if there is any evidence before you, in this case, regarding the defendant having committed acts other than the offense alleged against him in the indictment in this case, you cannot consider that evidence for any purpose unless first you find and believe beyond a reasonable doubt that the defendant committed such other acts, if any were committed, and understanding that said evidence cannot be used against the defendant as any evidence of guilt in this case. You may only consider that evidence for the purpose of aiding you, if it does aid you in determining the state of mind of the defendant, or to rebut a defensive theory, and for no other purpose, including instruction. The jury is permitted to receive evidence regarding the case from the witness stand. During your deliberations, you are not to consider, refer to, or discuss any matters or issues not in evidence before you. You should not consider, page 9, or mention any personal knowledge or information you may have about any fact or person connected with the case which is not shown to you by the evidence. You are not to talk about this case to anyone who is not a member of your jury. Your sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling is to play no part in your deliberation. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given to their testimony, but you are bound to receive the law and to follow the law from the court. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by the presiding jury, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you have. After argument of counsel, you will retire to the jury room and select one of your members as the presiding juror. It is the presiding juror to preside at your deliberations and to vote with you in arriving at a verdict. Your verdict must be unanimous. And after you have arrived at your verdict, you may use one of the, page 10, attached forms by having the presiding juror sign the particular form that conforms to your verdict. After you have reached a unanimous verdict, or if you desire to communicate with the court, please use the jury call button on the wall, and the bailiff will respond. Signed by me, Judge Birmingham, presiding judge, the 297 out here in Dallas County. Page 11 has the verdict forms. They are mutually exclusive. Cause number F1700576, the State of Texas versus Roy Durwood Oliver in the 292nd Judicial District Court, Dallas County, Texas. Verdict forms. We, the jury, unanimously find the defendant guilty of aggravated assault by a public servant as charged in the indictment, and there's a spot for the presiding juror to sign and print his or her name should that conform to your unanimous verdict, or we, the jury, unanimously find the defendant not guilty. And there's a spot for the presiding juror to sign and print his or her name should that conform to your verdict. Finally, the third charge. Cause number F17 00579, State of Texas versus Roy Durwood Oliver. The 292nd Judicial District Court of Dallas County, Texas, jury instructions members of the jury, Roy Oliver, the defendant, stand charged by indictment with the offense of aggravated assault by a public servant, alleged to have been committed on or about April 29, 2017 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. The following instructions are the law applicable to this case. You were instructed that you shall read these instructions as a whole. Offense definitions. A person commits the offense of assault if he intentionally or knowingly threatens another with imminent bodily injury. A person commits the offense of aggravated assault by a public servant if he commits assault and he uses or exhibits a deadly weapon during the commission of the assault, and he is a public servant acting under color of his office or employment. Page 2. Definitions of terms. Bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Public servant means a person elected, selected, appointed, employed, or otherwise designated as an officer, employee, or agent of the government. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Definitions of mental states. A person acts intentionally or with intent with respect to the nature of his conduct or with his conscious objective or desire to engage in the conduct. Page 3. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. Aggravated assault by a public servant. Bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about April 29, 2017 in Dallas County, Texas, the defendant, Roy Oliver, intentionally or knowingly threatened Maximus Everett with imminent bodily injury, and the defendant used or exhibited a deadly weapon, a firearm, during the commission of the assault, and the defendant was a public servant, namely a City of Balch Springs police officer acting under color of his office or employment, then you will find the defendant guilty of aggravated assault by a public servant as charged in the indictment. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict not guilty. Justification. It is a defense to prosecution that the conduct in question is justified under our law. Page 4. We are to consider the statutory defense of the third person in determining if the defendant is guilty of the offense alleged. You are instructed that a reasonable doubt on the issue of justification requires that the defendant be acquitted. In addition to the definitions already given, the following definitions apply to the issue of justification. Deadly force means force that is intended or known by the person using it to cause, or the manner of its use or intended use is capable of causing death or serious bodily injury. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Unlawful means criminal or tortious or both, and includes what would be criminal or tortious, but for a defense not amounting to justification or privilege. Deadly force in defense of a third person. A person is justified in using force or deadly force against another to protect a third person if, under the circumstances as the person reasonably believes them to be, the person would be justified in using force or deadly force to protect himself against the unlawful force or unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect, and the person reasonably believes that his intervention is immediately necessary to protect the third person. A person is justified in using force against another when, to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if he would be justified in using force against the other, and 2, when to the degree he reasonably believes that deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. A person who has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force as described by this section, and you may not consider whether such a person failed to retreat in determining whether the actor reasonably believed the use of deadly force was necessary, page 6. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about April 29, 2017, in Dallas County, Texas, the defendant committed aggravated assault by a public servant as alleged in the indictment, but you further find from the evidence or have a reasonable doubt thereof that the defendant reasonably believed that deadly force, when and to the degree used, was immediately necessary to protect Tyler Gross against the use or attempted use of unlawful deadly force by Vidal Allen. You will acquit the defendant and say by your verdict not guilty. If you do not so find, and you do not have a reasonable doubt thereof, you will reject the justification of deadly force in defense of a third person and find the defendant guilty of aggravated assault by a public servant as charged in the indictment. Constitutional rights. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of that offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant. Page 7. Unless you are satisfied, beyond a reasonable doubt, of the defendant's guilt, after careful and impartial consideration of all the evidence in this case, the state has the burden of proving the defendant guilty and must do so by proving each and every element of the offense charged beyond a reasonable doubt. This burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, it must acquit the defendant. The state is not required to prove the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes all reasonable doubt concerning the defendant's guilt. Evidentiary instruction. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might properly be admitted, and not be concerned with the reasons for such ruling or draw no inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you, of course, must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been, or as to the reason for the objection. You are instructed that if there is any evidence before you in this case regarding the defendant having committed acts other than the offense alleged against him in the indictment in this case, you cannot consider that evidence for any purpose unless you first find and believe, beyond a reasonable doubt, that the defendant committed such other acts, if any were committed, and understanding that said evidence cannot be used against the defendant as any evidence of guilt in this case. You may only consider that evidence for the purpose of aiding you, if it does aid you, in determining the state of mind of the defendant, or to rebut a defensive theory for no other purpose. Concluding instruction. The jury is only permitted to receive evidence regarding the case from the witness stand. During your deliberations, you are not to consider, refer to, or discuss any matters or issues not in evidence before you. You should not consider or mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. Page 9. You are not to talk about this case to anyone who is not a member of your jury. Mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling is to play no part in your deliberations. You are the exclusive judges of the facts, proof, of the credibility of the witnesses, and the weight to be given to their testimony, but you are bound to receive and to follow the law. From the court, after you have retired and considered your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by your presiding juror, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you may have. After argument of counsel, you will retire to the jury room and select one of your members as your presiding juror. It is the presiding juror's duty to preside in your deliberations and to vote with you in arriving at a verdict. Your verdict must be unanimous. And after you have arrived at your verdict, you may use one of the attached forms by having your presiding juror sign the particular form that conforms to your verdict. Page 10, after you have reached a unanimous verdict, or if you desire to communicate with the court, please use the jury call button on the wall and the bailiff will respond. Signed by me, Judge Graham Birmingham, presiding judge of the 2nd. Page 11 contains your verdict form. They are mutually exclusive. It reads as follows. Cause number F1700579, State of Texas versus Lloyd Durwood Oliver II in the 292nd Judicial District Court, Dallas County, Texas. Verdict forms. We, the jury, unanimously find the defendant guilty of aggravated assault by a public servant as charged in the indictment. There's a spot for the presiding jury to sign and print his or her name, should that conform to your unanimous verdict. Or, we, the jury, unanimously find the defendant not guilty. Again, there's a spot for the presiding jury to sign and print his or her name, should not conform to your verdict.